Criminal Law 1, Indian Penal Code in English language. Most important questions and tips. Dear student friends, in this class, I wish to enlighten you on what are the most important questions from Indian Penal Code, that is Criminal Law 1, how to face the questions for successful result is the topic I wish to take up now. In this lecture, I wish to suggest you to take 5 topics or 5 chapters in the first instance, and then 3 chapters, and then 3 chapters. Totally 11 chapters or 11 topics, and then the remaining topics as per your capacity you may follow. The reason is, in the examination, first impression will be the best impression. The examiner, on seeing the question paper, will go through the first answer to a particular question you have opted. And having seen the answer script, the first answer and second answer will create some impression on the examiner as to your candidature. When once you will be able to answer excellently first 2 questions, the examiner will have very good impression, and even if you continue the remaining questions not on par with the first 2 questions, the examiner will award you marks liberally. So that is why in every subject you have to give novel reading from first page to last page or first chapter to last chapter. When once you give novel reading, first page to last page or first chapter to last chapter from the book you have opted, it may be small number, it may be 100 pages or 1000 pages. But when once you give novel reading, you will have overall idea about the subject. It is a must for successfully facing the examination. In case you find it difficult to read the book you have chosen from first chapter to last chapter, I suggest you to watch my 2 videos on 2 summary videos on each and every subject, nearly 18 subjects I have uploaded so far. If you give second, if you watch second time this summary, you will get good idea about the subject. Then only you can pick out any question of your choice and follow. Now, I have selected the best topics and most important topics, not only from examination point of view, but also as a law graduate, law student or lawyer. After becoming judge also, you must have knowledge over that particular subject, particular concept. So, taking into consideration the significance and importance of its utilitarian value in your regular course of life as a law student, a law graduate, advocate, or judge, and its importance from examination point of view, that is, in sense, the incidence of the appearance of those questions are being repeated in most of the examination. I have selected uh, in first phase 5 topics or 5 questions. In second topics 3 questions are 3 topics. In third phase 3 questions are 3 topics. They are, I will tell you, I will give some introduction. I will list out, I will speak out the topics which I have taken which I have selected from examination point of view, and how to answer those questions. Which topics are more important? Which topics are comparatively less important? I am uh, going to let you know now. Now, in first phase, in just before going to that, I want to tell you, Indian Penal Code or Criminal Law 1 is broadly categorized into two parts. Part 1 contains 120 sections. 110 is divided into 5 chapters. Part 1 deals with general principles. It is in 5 chapters. Chapter 1 to 5. It contains 120 sections. And 120A for part 5A is subsequently added by Criminal Law Amendment Act. It contains two sections, 120A and 120B. That speaks about criminal conspiracy and punishment for criminal conspiracy. 120A defines criminal conspiracy. 120B prescribes punishment for criminal conspiracy. This concept, criminal conspiracy, sometimes used as principle, sometimes it is used as specific offense. So, in order to prove some specific offense like murder, rape, kidnapping, this criminal conspiracy is used as a principle. Suppose A and B conspired to kidnap C, or A and B and C conspired to abduct an MLA to meet their demands from the government, like that. So, criminal conspiracy sometimes treated as principle. For criminal conspiracy itself, case can be filed. How we file case for murder, rape, kidnapping? For criminal conspiracy also, case can be filed. That is why this 5A containing section 120A and 120B is sui generis, we can call it. It is sometimes it is used as principle, sometimes it is used as a specific. From chapter 6 to 23, chapter 6 to 23 containing sections 121 to 511 divided into 18 plus 2 chapters. 18 plus 2 chapters. Chapter 6 to 23. 18 chapters. By subsequent amendment acts, section chapter 9A. Chapter 9A is added relating to election law amendments, and 20A is added relating 20A containing section 498A relating to dowry death. The dowry death. Cruelty of husband and his relatives in respect of dowry death. The same concept we study under section 304B. So these are the actual. Here I want to tell you chapter 1, part 1 of Indian Penal Code contains 5 chapters deal with part 1 deals with general principles. In general principles, all the chapters deal with one particular concept. For example, crime, meaning, definition, elements, etc. It speaks about one concept, that is crime. Next, one chapter, joint liability, it speaks about one concept, that is joint liability is one concept. There are two sub concepts, that is common intention, and common object. Just two topics. Similarly, vicarious liability, jurisdiction. So each chapter speaks about one particular concept or one particular aspect only. Similarly, theories and kinds of punishment is only one chapter. Is that like that? Accordingly, abetment. According what only one chapter, that is a chapter 4, deals with general exemptions or general exceptions. Under this, the accused can plead one of the defenses to get exemption from criminal liability. So, there are only chapter 4 contains so many concepts, so many defenses. The other chapters deal with only one topic only. So, in Part 1, the number of chapters are very limited, that is 5, and each chapter deals with one or two topics except chapter 4. That is why this it is very easy to prepare part 1, but well, it is not so easy to prepare part 2 that deals with specific offenses, that is from chapter 6 to 23. From chapter 6 to 23, including two added chapters, 9a and 20a, all these chapters contain number of concepts. For example, offenses against human body. So, murder, culpable homicide, negligent death by rash and negligent accident, hurt, grievous hurt, miscarriage, abetting a person to commit suicide. So many abetting a person to commit suicide by giving false evidence in respect wherein the innocent is committed suicide, like that. So there are so many offenses or concepts or topics under one chapter. Similarly, offenses against property, theft, robbery, dacoity, extortion, mischief, criminal misappropriation of property, purchasing stolen property, like that. So many things will come. Offense against marriage, bigamy, adultery, and others, elopement and all. So, in part 1 contains very limited chapters, that is 5 chapters, but the concepts that are dealt with are very limited. But whereas part 2 specific offenses deal with so many chapters, 18 plus to 20 chapters. Part 1 5 chapters, but 5a is not only a principle but also a specific offense. So here part 1 we discuss principles. In part 2 we discuss specific offenses. That is why in some universities I am given to understand part 1 principles is one subject, part 2 specific offenses is prescribed for study as one subject. But in my when I was studying LLB, there was a book on R.N. Saxena. He dealt with only principles only. That book contains only principles. It doesn't contain specific offenses. Almost all textbooks on Indian Penal Code, that is Criminal Law 1, deal with principles and specific offenses. Now coming to the point, that is why we can rightly say that we may say that the part 1 is one third or one fourth, whereas part 2 is 2/3 or three fourth syllabus, we can say. That is why even once you are supposed to face examination on Indian Penal Code as a whole, that is principles and specific offenses, I advocate you to complete all the topics in general principles. In specific, first of all, you start reading culpable homicide and murder, which is most expected question. I don't think in almost all, I don't think whether there is any question paper without this question on culpable homicide and murder, such a important thing. So now I want to tell you, at the same time, you people have doubt that the Indian Penal Code is going to be amended totally. The is going to be codified. The Bharatiya Nyaya Sanhita Bill 2023 has been presented in Lok Sabha on 11th August. So this IPC will be no more. That doubt you need not have. This syllabus will be continued for this academic year and next academic year also. I hope that for to it may take some time. And what regard to clarify these doubts, I will enlighten you on the three bills presented in Lok Sabha to replace to repeal three criminal law enactments, namely Indian Penal Code, Indian Evidence Act, and Criminal Procedure Code. What is the significance also? I will tell you. Now, first of all, first I will list out what are the topics I suggest you to read in the first. You read first chapter to last chapter. You give novel reading first chapter to last chapter, so that you can have good idea about the subject. What is the subject? What the subject deals with? What are the topics studied? And what are the topics? What are the topics we are expected to study from this particular subject? You will get some idea. Then first you give novel reading first chapter to last chapter from any book you have chosen, or you watch my videos on summary videos. For IPC, long back I gave summary on Indian Penal Code in two lectures, and also Indian Penal Code at a glance. I think two lectures are there. Now in I while starting Indian Penal Code along with Telugu students, I have given summary, one lecture on principles, one lecture on specific offences. Within, if you can spare 2 hours to watch my lecture on for 1 hour for principles and 1 hour for specific, you will get overall idea about the subject Indian Penal Code. When once having got an idea about the subject, you first start preparation. First five topics from four topics from principles and one topic from specific. They are: number one, crime, the concept of crime, meaning, definition, elements, etc. You have to prepare first, because when you the beginning chapter you are expected to read first. Normally, any question paper on any subject, the first question normally is from first chapter. So crime, meaning, definition, elements, etc. in this with particular reference to mens rea. If the question is asked how to answer, I tell you, I will list out all the 11 topics, and then explain you. If that question is given, how to write all these tips, I tell you. So now first phase you have to read crime, meaning, definition, elements. That is extra in the sense stages. Particular reference mens rea. Second one is culpable homicide and murder. Second, after completing crime, meaning, definition in principles, you go to specific crimes, and you go to culpable offenses against human body. First topic, culpable homicide and murder. First one is crime, meaning, definition, elements. Second one is culpable homicide and murder, and distinction between culpable homicide and murder. Second one. Third one is joint liability. Joint liability. That is common intention, section 34, common object, section 149. Joint liability. Fourth topic is abetment 160, 107 to 120. 107 to 120 is abetment, and fifth one is theories and kinds of punishment. So when once you preparation when you start preparation for Indian Penal Code, either you give novel reading from first chapter to last chapter of the any book you have opted, or you may watch my summary lectures, two lectures on the subject. Next, IPC for crime meaning, definition, elements and stages. First one. Second one is with particular reference to mens rea. Second one is culpable homicide and murder. Third question you have to prepare joint liability, that is common intention section 34 and common object section 149. Next one is abetment section 107 to 120. Fifth one is theories and kinds of punishment. When once you prepare these five topics, you are expected to get two questions, two or three questions according to my experience. If you go to library and verify the question paper, out of these five you will find not less than two questions. If you prepare these five topics very excellently, you prepare a notes on your own. You should prepare a, when you read, if you read you get sleep, you start writing, you're sleeping, you can avoid sleeping by writing. By writing you can avoid sleeping, and also you can maintain good handwriting. As a student, as a lawyer, as a judge, you should not stop rewriting habit. When once you write, your writing will be good and your writing will be legible. While writing answer, while writing answer on the answer book, you have to maintain good handwriting. If you unfortunately your handwriting is not good, you must try to practice legibility. What you are writing, the examiner should understand. You is expected to identify what you are writing. If you write whatever good you write, if the examiner won't be able to understand because it is highly illegible, then sometimes even if your performance is good, you may not get expected marks. So this in first stage you read crime meaning, definition, nature, elements, culpable homicide, joint liability 34th 149, abetment, theories and kinds of punishment. This theories and kinds of punishment is appears on three subjects. First year Indian Penal Code, second year jurisprudence or legal theory, third year final year, that is criminology and criminal administration, or criminology, penology and victimology subject. It may be a compulsory subject or optional subject, depends upon the university concerned. Next, first phase 5 questions you prepared, and second phase you go to general principles, defenses. In defenses there are so many there are so many defenses, and chapter 4 of Indian Penal Code deals with defenses. What are the defense? There is a judicial acts, infancy, insanity, intoxication, compulsion, necessity, consent, like that. So many right of private defense, so many defenses are there. But out of all the defenses, you should concentrate section 84, general insanity, that is mental. If a mental person, if a pagal person, mental person commits any crime, he is not. Suppose in a mental hospital, one mental patient kills doctor or nurse. That patient, mental patient, who is insane, under section 84, exempted from criminal liability. Infancy, a child below the age of 7 years commits crime, exempted from liability. 8 years to 14 years subject to proof of mens rea. Beyond that is that boy or girl is put under observation in a Boston school or a correction institution. So all these things are there. Here, below 7 years, say 8 to 12 years, subject to proof of mens rea. All these things I will tell you. Now, coming to the uh, second phase, three question. In defenses, you concentrate insanity 84 and right of private defense section 96 to 106. Means defense insanity means mental person commits crime, no case. And if a person kills somebody to protect himself, then there is no. Suppose some robber knocks the door, enters into the house, pointing pistol or knife, attempt to kill the inmates of the house. If any inmate catches him and kills him, that inmate of the house, resident of the house, is exempted from criminal liability. That is the right of private defense. So here, in a watchman in ATM or a bank during night time, any robbers enter, then in order to protect the property, public property, that watchman may fire at the culprits. Then that watchman, in order to protect the property and to save his life, is exempted from the criminal liability. That is right of that is so. In defenses, to these two topics you have to concentrate. Then vicarious liability. Second one is vicarious liability. Vicarious liability is unknown to criminal law is the question asked now and then. But whether irrespective of this concept, whether vicarious liability in criminal law appears or not, it is a good question. But as a law student, you must know about vicarious liability in tort law, vicarious liability in criminal law. So this, for vicarious liability in criminal law, you can take the background of law of torts, you can take the background of elements of crime, mens rea, position in English, position in England and position in India, that is position in England and position in India, that is Srinivas Mal case and Rahul Hariprasad Rao case, you can take into account in this particular topic. So, vicarious liability, generally the master has the civil liability, master has no criminal liability. If the lorry driver commits accident and kills a man on the road, a pedestrian on the road, the owner of the lorry will have to meet the civil liability, that is compensation to the next kith or kin of the deceased, but he will not be imprisoned. But however, the driver for committing an accident may be imprisoned under section 304A if negligence is proved while driving. So here, now next one is third question is jurisdiction of criminal court. In IPC, the jurisdiction section 1 to 5 lay down various provisions relating to jurisdiction. This jurisdiction you study in CPC. I gave lecture in CPC. I gave lecture I uploaded one lecture in criminal procedure code and hierarchy of criminal courts. What is the competence and jurisdiction of lower courts, high courts, supreme court, from what the powers and functions of lower courts, that is subordinate courts, high court and supreme court. I gave lecture. If you come as a law student, as a law graduate, as a lawyer, or as a judge, you are expected to know in detail about jurisdiction. So what is this? You are advised to read this jurisdiction in IPC and jurisdiction in CPC and jurisdiction of civil courts in CPC and jurisdiction of criminal courts and in CRPC. So in second phase defenses, first question is 84 and insanity and private defense. And seventh question, vicarious liability. Eighth question is jurisdiction of criminal courts. Now in third phase, so far I have told you 8 question. First phase 5 question, second phase 3 question. Second phase 3 question means defenses, under defenses, insanity and private defense, right of private defense. Second topic is vicarious liability in criminal law. Third one is jurisdiction of criminal court. These are the three topics. And thirdly, in third phase, you have to study three more questions. And from offenses against human body, you in that chapter you study first hurt and grievous hurt, kidnapping and abduction. Kidnapping means kid means child, napping means nap means steal. Kidnapping means child stealing. If a child is taken away, it is kidnapping. If an adult person is taken away, it is abduction. Suppose a woman is abducted to export to foreign countries, like a movie Bola Shankar in Telugu. It is called abduction. If an MLA or MP or politician, some other politician or an IAS officer is kidnapped by the kidnapper, abducted by the abductor to meet the demands, then it is called abduction. If child is abducted, it is kidnapping. If it adult is abducted, if it is taken away, it is abduction. Next one is rape. There is a lot of developments in rape which dealt with section 375, its punishment 376. So many changes, so many amendments have been made on this topic. So then the first topic is from offenses against human body. You have to study, concentrate, and in that offense against human body, hurt to grievous hurt. Hurt means causing injury. Grievous hurt means disfigurement or loss of limb, loss of eye, serious. That is hurt, grievous hurt. Next, kidnap, abduction. Rape. What do you mean by rape? So these topics you have to study next. Next, offense against property, theft, robbery, dacoity, and this all these topics IPC I covered earlier long back these topics. You may refer, and if possible, I will repeat these topics once again. So next one is offenses against marriage, bigamy, adultery, dowry death, bigamy, dowry death, and last one dowry death. So these are the topics you have to read. In addition to that, you have to dowry death, and next one is fourth topic you have to read is offense against women. Offense recent development is section 354. Section 354 offense against women has been expanded. 354A, 354B, 354C, 354D, 354A sexual harassment, 350B disrobing of women, undressing woman. Next, 354C voyeurism means suppose a woman changes clothes in a private place. If anybody watches that, erects some CC camera like this, an invisible CC camera like that, that person is punished under this. And 354D staking. So pursuing a woman, following a girl, seeking her love, proposing a woman against her will, and following her everywhere. That is called staking. That is what so many boys will do. There are some incidents of acid attacks. If the girl refuses to love a boy, that boy started attempting this acid attack also. You have to study. In addition to that, whatever topics you may read, because this IPC is a very big volume. Now there are so many topics. Wrongful confinement, wrongful restraint is there, criminal breach of trust is there, criminal breach of trust, misappropriation of property, unlawful assembly, cheating, mischief, criminal trespass. These topics are important from next phase. So, however, the IPC, then in specific, there are nearly 100 offences. 100 topics are there. Nearly 80 to 100 topics are there. I have given you a limited number of topics which are very important from examination point of view. However, you study in the first phase 5 questions or 5 topics, 4 from principles, 1 from specific. That is crime, concept of crime. Second one is culpable homicide murder. Third one is joint liability, 34 and 3149. Fourth one is abetment. Fifth one is Fifth one is the theories and kinds of punishment. The five topics. So four topics are independent topics. For one, murder and culpable homicide is from part two, specific offences. And in the second phase, I told you three questions. General defenses. There are so many topics. You read 84 insanity and private right of private defense and 96 to 106. You read it. And second topic you have to follow from this is uh, first one is defenses, second one is uh, second one is defense. First one is defenses, vicarious liability, jurisdiction. Vicarious liability, jurisdiction. As a law student, you should know for vicarious liability, you take the help of torts and from this Mensiria topics. Srinivasmal Rahul help us will come. Jurisdiction, CP, you study. You have to prepare jurisdiction in IPC, CRPC, and evidence in CPC also. And third phase, you have to read hurt to, grievous hurt to, kidnap, abduction, rape. This is one topic from against offense against human body. And offense against property, theft, robbery, extortion, dacoity. Next, offense against marriage, bigamy. Bigamy means marrying again during lifetime of spouse. If a man or woman marries again during the lifetime of life partner, it amounts to bigamy. If more than two wives, it is polygamy. More than two husbands, polyandry. Polyandry. Only two husbands or two wives, it is bigamy. That is offense against marriage. The concept you have to study is bigamy. The adultery. Second one is adultery. If a man is having affair with a married woman, it amounts to by adultery. It amounts to adultery. Dowry death, which is most common in so many places. If for the purpose of dowry, the married woman is burnt alive or killed in order to get the groom married to met the boy to get married to some girl who brings more dowry or who is more who is rich. So these are in addition to that the recent development is recent development, dear friends, that is offense against your woman, offense against woman, modesty of woman, that is sexual harassment is a very recent development. That is why in the recent past exclusive ladies banks are in some banks, only all the staff members including class 4 employee peon are ladies. That attempt is made. There are exclusively ladies banks are there containing exclusively ladies. We know for since long back women's colleges, men's colleges, women's hostels, men's hostels, like that. In every some banks, all staff members are ladies. So because to avoid this sexual harassment. Okay, Visakha case I explained in detail in maintenance. Then 354A, sexual harassment. You have to. I will explain its punishment, etc. 354 is expanded. 354B deals with disrobing of women. Disrobing of women is what happened in case of late Honorable Chief Minister of Tamil Nadu, Mrs. Jayalalitha ji. She was subjected to this offense. And the third one is 154 354C is voyeurism. So in some cases, when the customers when they are in their room in some lodges, couple are there. Couple there, some invisible CC cameras are maintained in some shopping malls, in dressing rooms of ladies. Some invisible CC cameras are erected, and those obscene scenes were encashed by the culprits. So that is called voyeurism. And the last one is staking. It is quite common, which we find the youth, young men follow the young woman, putting consistent and persistent demand to love them In the event they failed, they refuse, there are some instances to attack the girls with acid attacks also we have seen. So there is a further development is offences against not only women but also children took place in one recent case, some Zuwa case or something, I don't remember, and 8 men including police officers raped a girl of 8 years. So these are the so many nasty things are being taken place, and this thing. So, you dear friends, this syllabus will continue for this examination and next year examination also, I think. But our you people think that in Indian Penal Code is going to be repealed, going to be abolished, and new Indian Penal Code, that is Bharatiya Nyaya Sanhita BNS Bill 2003 has been introduced in Lok Sabha. So the IPC will be deleted, IPC will be vanished, and new Bharatiya Nyaya Sanhita Act will come, you may think. But it may take some time, dear friends. It is not so easy to replace or abolish such vital enactments. So the entire judicial system, criminal justice system, is based on the entire judicial, the entire criminal justice system is based on three pillars, namely Indian Penal Code, 1860, Criminal Procedure Code 1898, and then 1973, and Indian Evidence Act 1872. The Indian criminal justice system is based on three pillars, namely IPC, CRPC, and evidence. The Indian judicial system is based on four pillars, namely IPC, CRPC, evidence, and CPC. The civil justice system is based on is run according to CPC, criminal justice system according to this. So evidence is common to civil justice and criminal justice. CPC, CRPC, evidence, and IPC. CPC, CRPC, IPC, and evidence are the four pillars of Indian judicial system. We can say the constitution the constitution is authority guiding. It is authority that contains guiding principles for functioning of judicial system. So, as per the directions, as per the guidelines, as per the provisions of Constitution of India, all the four pillars or many other laws are framed, drafted for successful administration of our judiciary in India. So these most important enactments before come into force after gazette notification, they will be examined very thoroughly, very thoroughly. They do not do it in overnight, is what I opine. It is my opinion, because there are these, when once a legislation is to be amended, they take lot of precaution. They take the government will place these enactments before passing before the public. These three legislations were referred to so many authorities prior to 4 years. High courts, Supreme Court, high courts, state legislatures, assemblies, public, and all. And they have to taking that, if they presented in Lok Sabha, and then it should be passed by Lok Sabha by simple majority, and then it should go to Rajya Sabha. Before that, these three bills are referred to Parliamentary Standing Committee for elaborate discussion, to hold elaborate discussion. So because it is not so, they do not do it in a hurry way. For example, 4 years back, that is in 2019 and 20, 2019 and 20, 29 labor legislations have been were consolidated into four labor acts, four labor codes, four labor codes. 2019 and 2020 they were presented, but they have not yet been passed into law. Similarly, Consumer Protection Act was originally passed in the 1986, and it was amended for it was being amended from time to time, and it was recodified sometime in 2019, and ultimately it was passed and came into force in the year 2022, 2022 July 14th, I think. No, till then, though the Consumer Protection New Act was passed in 2019, it came into force. Similarly, Motor Vehicles Amendment Act originally 1939, it was recodified in 1988. It witnessed so many amendments, and subsequently Motor Vehicles Amendment Act came in the year 2022. But still, after 2002 Amendment Act also, some amendments took place in 2023, and which speaks about the any vehicle which is 15 years old, it must be demolished. It must be demolished. It must be broken. It must be broken into pieces. So that is the so many developments are there. In addition to that, I wish to tell you that yes, in 2023, at the time of presenting the three bills, Bharatiya Nyaya Sanhita Bill to replace Indian Penal Code, Bharatiya Nagarik Bharatiya Nyaya Nagarik Bill (CRPC), Bharatiya Saksha Bill. This is evidence to replace evidence. When these three bills were presented in Lok Sabha by our Honorable Union Home Minister Amit Shah ji, and there were 216 bills pending in 216 bills pending in Lok Sabha or Rajya Sabha, or both Lok Sabha and Rajya Sabha. 216 bills are to be passed, approved by Lok Sabha, Rajya Sabha, Assent, Home Ministry, Gazette notification. Then only they will become laws. But these 216 bills are pending for last few years. So a bill presented in Lok Sabha and Rajya Sabha to become law, it may be passed into law in few days or few months or few years. We cannot say, depending upon the situation. So we need not have any confusion that this syllabus may be changed in the near future. So you may simply concentrate on this subject and appear for the examination. Dear student friend, these are the things I have done. So I told you the what are the topics for first phase 5 question, second phase 3 question. First phase 5 questions I repeat: crime meaning, definition. Second one is culpable homicide murder. Third one is joint liability. Fourth one is abetment. Fifth one is theories and kinds of punishment. You first prepare 5 essays on this. If you prepare essays with your own handwriting, you don't get sleeping. When you feel when you are in sleeping mood, if you start writing, you can avoid sleeping. And if you read more time, if you read more time, you may get sleep. If you write more time, you don't get sleep. To avoid sleeping, you start writing. That is, by writing on your own, your memory, you will be able to remember the points very well. That is first reason. Second, you can avoid sleeping. Second point. Third one is your handwriting will be improved. If your handwriting is good, the exam will have very good impression and you will get good marks. No, while writing the question, adjust your time to all the questions. Never leave any one question. Suppose last two questions are there, each question is 5 marks, 5 marks. If only 20 minutes is 10 minutes is left over. For instead of spending 10 minutes for one question, you give 5 minutes to one question and 5 minutes one. You incomplete the answer. but keep the remaining 5 minutes to next question. If 5 plus 5, if you write only one question of 5 marks, you may get maximum 4 marks, 3 to 4 marks. If you add, if you give 5 minutes to one question and 5 minutes to another question, 2, 3 marks, 6 marks you will get. 6 marks you will get. If you allocate whole time for 10 minutes for that, 3 or 4 marks you get. If you allocate 5 minutes to two questions, you will get 3 marks, 3 marks, 3 to 4 marks, 6 to 7 marks you will get. Sometimes even 1 mark will help you. There are so many cases where many students failed just in 1 mark, just in 1 mark. As an examiner, he has to look into the matter. When there is margin is 1 or 2 marks, the examiner is, I suppose, expected to add that 1 or 2 marks and pass the candidate. If at all the examiner wants to fail, the margin he has to maintain not less than 5 marks is what is my opinion. So these are the questions, dear friend. Indian Penal Code is most important subject. There are 5 subjects in first semester. These 5 subjects, there are 5 subjects in first semester. First semester 5 subject. IPC is very difficult because IPC part 1 principles is 25 to 30%, but whereas part 2 is 70 to 75%. But IPC part 1, all questions are important. In most important question, I have given you all the topics in question. So in one chapter deals with 1 or 2 topics in principle, but in specific one chapter deals with many topics, many offenses. So the volume is more. But that is why you read in first instance 5 topics, and second instance 3 topics, third instance 3 topics, 3 topics. Suppose there are a candidate who won't be able to prepare beyond the first top 5 chapters you read, and you write anything what you know. You read anything, you attempt the question and answer all the questions, whether it is relevant or irrelevant, it is immaterial. But what you know, the best questions you write first. What questions you don't know, you don't leave it. You put question number and write something. Write something. The examiner is kind enough, he may give you 1 or 2 marks, 3 marks. If the examiner doesn't see out of hurry, he may give you more marks. If the examiner clearly sees, he may give 0. But there is nothing. Leaving the question 0, writing something getting 0 is 0. Luckily you may get 2 marks, 5 marks, or even more. You cannot say. So it is luck. That is why don't leave any question on the ground that you don't know. You write anything what you know. You just simply ink the paper and come out of the examination. You may luckily, so you may correct your difficulty, you can correct your mistake by reading those concepts in future. So that is why, dear students, these are the topics. So what are the precautions you are? Well, crime. First question I told you. I will highlight and give some tips. First question: meaning, definition, and elements of crime. In this question, define crime. I will ask. If it is the crime is asked in criminal law, criminal administration, Garofalo definition quotation they mean. Crime is a social phenomena. Crime is a social phenomena discuss. So crime is a social phenomena. It varies from place to place and place to place and person to person, place to place and situation to situation. These aspects also I explained in previous classes. So that is on that you have to write the crime meaning definition here. So this social phenomena refers to that subject, but here not. In question is asked meaning from first question, define crime and what is the nature of crime. Suppose if you have to write the meaning of crime. Meaning means the crime is a crime, Latin maxim. From which Latin maxim it is derived? Latin or Greek or French. That meaning and definition. 1 or 2 best definitions. 1 or 2 Blackstone and Solomon or Kenny are most important. There are 10 more than 10 definitions will be there in book. You have to select 1 or 2 definitions. You write it, and next meaning 3-4 lines. Definition 1 or 2. IPC definition, CRP definition is there. 3-4 lines. around 8 to 10 lines, you finish meaning and definition. Then elements of crime. 4. Human being, mens rea, act, uh, physical act and injury. 4 points are there. So some generally you write 3 topics simply, and you have to write for human being 2 lines, 2 3 lines enough. For mens rea you have to write more, English law, Indian law, and everything. For physical act you have to write small paragraph, and injury you have to write 3 4 lines enough. 3 4 lines enough. So sometimes question is asked as main on my mens rea. If quasi actors re-amnesty mens rea discuss, that is the quotation. This quotation refers to common law doctrine of mens rea. Mens rea, you are right. Mens rea means mental element, evil intent, guilty mind. It is based on the Latin maxim actus reum nisi mens rea. Then you have to write out mens rea. The mens rea is not defined in Indian Penal Code. It depends upon it varies from defense to offense to offense. For murder, the mens rea is something. For rape, mens rea is something. For pickpocketing, mens rea is this much. For theft, mens rea is something. Like that, you have to write only mens rea, English law, personal law. When question is asked on mens rea, you mention 3 points also, write 1 line to one thing. If all elements are asked, you have to write more about mens rea, little about physical act, and 1 or 2 lines about human being and injury. Enough. So here, if sometimes actus reus, that is physical act, may be asked as short notes also. See, first question is over. Second question is a common intention, common object. Common intention, common object. Common intention, common object. 34 is Barendra Kumar case. Barendra Kumar case. Um, uh, Abdullah, Kashim, some case is there, common intention. This and this. Mehboob Shah case. Barendra Kumar case, Mehboob Shah case, you have to write for joint liability. And common object, section 149, you present some information about unlawful assembly under section 147. The 5 situations you have to write, common intention, common object. And culpable homicide, murder is the most important. First of all, even if you write culpable homicide and murder, is very good. Culpable homicide, murder, there is a lot of confusion, but culpable homicide is most likely 90%, 90 to 99%, there is a chance to ask question on culpable homicide and murder. First, crime meaning definition. Second, culpable homicide, murder. Third one, joint liability. Fourth one, abetment. Because nobody will do crime with his own hand. He will engage somebody to do crime. Suppose a rich man gives some sufari, that is some money, 5 lakhs or 10 lakhs to some gangster, and ask him to kill somebody. That rich man is called abatar. The person, that gangster who kills his own eyes, is called principal offender or principal in the first doing. There are different modes of abetment is there. Different types of criminals are there, that I already explained long back, and I will repeat it if time permits. Next, theories and kinds of punishment. So there are 5 theories and 5 kinds of punishment. This is this last I uploaded this lecture. So far in criminal law revision, crime meaning definition I uploaded, summary 2 lectures I uploaded, and joint liability I have uploaded, and theories and kinds of punishment I have uploaded. From general principles I will to complete abetment and vicarious liability, and general defenses I have to complete. Then I shall proceed to IPC. So the first phase, these 5 questions you read. In the second phase, general defenses, that is insanity 84, right of private defense, you have to read vicarious liability, and jurisdiction. Vicarious liability jurisdiction, you should know, irrespective of their appearance in the examination. Vicarious liability you should know as a law graduate. And sometimes question is asked, vicarious liability is unknown to criminal law, you have to write. And then jurisdiction, I gave lecture in jurisdiction in IPC long back, and I gave one lecture in jurisdiction CPC, one lecture in two lecture in one lecture jurisdiction of criminal courts, and he hierarchy of criminal courts also I have given. And these second phase defense, vicarious liability jurisdiction, second phase. Third phase, you have to read hurt to grievous offense against human body. There are so many offenses against human body, but you have to read three topics: hurt to grievous, hurt to kidnapping, abduction, rape. And next, second topic is again offense against property, theft, robbery, extortion, dacoity. There are many other offenses against property, but I have told you to concentrate these three. And offense against marriage, only the two: adultery and bigamy. And last one is dowry death. In addition to that, you may read so many topics. There are so many other topics, and you have to concentrate on recent. There is section 354 is expanded regarding against atrocities or offenses against women. It is a very serious. The government is taking it is very serious. So here in our criminal law amendment bill, criminal the Indian Penal Code Amendment Bill, that is Bharatiya Nyaya Sanhita Act 2030 BNS B 2023. At the time of Indian Penal Code is passed, there were 511 sections divided into 23 chapters. After subsequent amendment acts, criminal law amendment acts, and other acts, the number of sections, there are number of sections are 78. The number of sections are number of amendment acts are 78. The number of sections rose to 576 from 511. Originally, IPC contained 23 chapters. Originally, IPC contained 23 chapters. It contained these 23 chapters contained 511 sections. After 78 amendment acts, the number of sections rose to 576 from 511 to 576. These sections increased, and three chapters are increased: 5A, 9A, 20A. 5A criminal conspiracy, 9A relate to election laws, 20A relating to dowry death. So these only fifth 5A contains only two sections: 120A, 120B. 9A contains so many elections bills, 171 A to I, like that. And chapter 20A contains only one section, 498A. So it is also read with 304B, dowry death. So this is the now this today there are the present old Indian existing Indian Penal Code. There are 576 sections divided into 26 chapters, 23 plus 3 added chapters. Now all the 570 sections are to be revised under the have been revised under the Bharatiya Nyaya Sanhita Bill, BNS Bill 2023. From this number of sections are reduced from 576 to 356. They wanted to avoid confusion of 576 sections. They have restricted the number of sections to 356 sections. 176 sections of the have been under old code, present code, have been revised or amended or changed. 8 sections are added, 22 sections are deleted. So the sedition also was is proposed to be deleted. So these are the I think. Dear friends, like that, there are so many in Indian Constitution also was drafted, came into force in 1950. It has 105 amendment acts, 105 amendment act. There are more than 30 amendment bills pending. Indian pay not only almost all legislations in force at present were codified were codified during British rule and enacted by the British Parliament. We are following those laws even today. We are following those laws even today, but we are managing with amendment acts. Very few acts. In Companies Act 1956 was recodified in the year 200 to 2013. Even though any act is recodified, old sections will be repeated in a new act, but the section numbers may be changed. The contents may remain unchanged. The contents of old sections remain unchanged in most of the section, but some new sections may be added, some old sections may be deleted. Overall, the old law and new law will be substantially okay, but there will be same, substantially same, but partly changed. So don't think that when once an act is repealed and replaced, so even Indian Constitution is based on Government of India Act 2000, Government of India Act 1919 and 1935. So wish you all the best. Like this, I will give important questions first. I will complete at least. You will read summary and this. Thereafter, you will concentrate on this. Dear student friends, please note that if my lecture title contains in Telugu, that is only Telugu language. But almost all my lectures are in English only. If in Telugu is not there, that is all lectures are English, mostly English. If the title of the lecture contains in Telugu, it is only Telugu. You need not watch that. English students, you not watch. But Telugu students should are advised to watch not only Telugu but also English, because there will be some new points. There will be some difference between Telugu lecture and English lecture also. Whatever points I forgot in Telugu lecture, I will include in English lecture also. So far as content is concerned, the English lecture may be better so far as the content of subject. Thank you very much for your patient hearing. All the best.